Hello, everybody. Welcome back to Conduct Detrimental Podcast. This is your co-host, Dan Worley, partner at Siebert Worley in Nashville. I'm joined, as always, by my other co-host, Dan Wallach. Dan, what's happening?
Just living the dream here in South Florida. So, anyway, I'm looking forward to this podcast. We have a lot going on this week. We've taken I don't know if we've taken 2 weeks off, but it just seems if you miss a few days, the stories are just flying fast and furious. And the best example of that is what's going on this week. So why don't you tee it up?
Yeah, well, I think it's an incredible time in sports law, I think. I mean, I can't think of a time where there was more issues going on nationally, throughout college sports, throughout professional sports. We've hit on sports betting a lot. That case is coming soon in the U.S. Supreme Court. But, I think specifically, and I don't think we'll get into this too much, but the national anthem talk and how each team reacted this past week, and, of course, the president's tweets. And, earlier today we saw the Broncos put out a statement that they're all going to stand, and it's just very fascinating to me that all playing out. But I think the one bit that we wanted to start off with, and we'll also get to the Ezekiel Elliot lawsuit update a little later on in the podcast, but I think what we wanted to start off with and touch maybe more on a high level and just try to talk about some of the broader potential impacts of this case. But the college sports bribery case, there were, a bunch of arrests made this week. The FBI did an investigation, and there's 10 schools implicated, 10 people. It looks like at least 7 schools. We had 4 assistant coaches arrested, a few other people. Pretty wild story. Huh, Dan?
Yeah, and we haven't even scratched the surface on this yet. We've barely gotten into 1 or 2 days, and there have been a number of schools implicated. But my favorite quote from the United States Attorney in the Southern District is, "We've got your playbook. You better come talk to us before we go find you." And I would suspect that this is going to multiply in fairly short order, not only by school across the country, but I think by sport. College basketball has its own unique relationships, and but I think college football will ultimately could find itself under the microscope in this far-reaching investigation. I think these comments from the acting United States Attorney in the Southern District really are going to be prescient, and we're going to see this the scope of this multiply pretty quickly.
Yeah, I couldn't agree more. I think, and we'll get into a few of the specific examples, but I think one way it's going to multiply quickly is, we have, people arrested, people facing criminal charges. This isn't an NCAA investigation at this point where, maybe the school, maybe they're get a slap on the wrist like we saw with Pitino last year in the escort scandal where he got suspended a few games. This is people going to jail for what they're doing, and it's a big deal, and that means that they could be cutting deals with the government and agreeing to either provide more information or testify against other witnesses. And so I think through that process, we're going to see this thing really expand, and especially when you kind of take into consideration that it's not necessarily just these individual schools involved, but it's a shoe company, at least one shoe company at this point, Adidas, and Adidas could be doing this on a far broader scale.
Yeah, that's a great point. But I'm wondering whether culpability should stop at the doors of the coaches and the individuals involved. What about the institutional culpability? In one sense, the universities are being portrayed or painted as being victimized. Well, I think the true victims are the student athletes. But the schools themselves pay a steep price through NCAA type sanctions as well as criminal penalties. The NCAA ends up looking pretty ineffective and ineffectual here. That activity, which everybody knows is the way this business is run,
right,
is operated with basically impunity for so many decades, and the NCAA has been powerless or gutless to do anything about this because they quote unquote lack the subpoena power. Well, there are other ways to compel this kind of information, and obviously it's left to Preet Bharara's former office to do the heavy lifting major investigation and criminal investigation in the world of sports or gambling. That's the office that broke open with on the illegal world of online poker with, I don't know if it was Black Monday or Black Friday, but that office is famous for bringing some of the most important far-reaching criminal investigations, at least as I've seen in the gambling industry, and now this is going to be probably the most serious institutional sports prosecution of my lifetime.
Yeah, I mean, on one hand, I somewhat agree with you. On the other hand, it's if when I did sit down and take a look at some of the documents and how the FBI actually went about this investigation, it's hard to imagine at least how the NCAA's enforcement team is set up that they would have had the ability to do this, right? I mean, you saw things like wiretaps, undercover witnesses, undercover officers. I mean, it was a pretty elaborate thing that I think is probably outside of the NCAA's capability. But that being said, like you said, it's not the only way to do it. Yeah.
Yeah, that's a good point. I mean, it was the cooperating witnesses, or witness in this case, that really, kind of broke the dam and laid everything bare for the United States Attorney's Office to go after. In an NCAA internal investigation without that kind of threat of criminal penalties, there would be a lack of incentive or motivation for somebody to be a cooperating witness, unless it was to save his own skin, like one coach would be turning, evidence on another coach or another school. But here, one of the cooperating witnesses, I forget his name, Melvin something or other, faced, significant penalties criminal penalties for having stolen money from athletes to finance his movie ventures. So the U.S. Attorney's Office and federal criminal law enforcement authorities have a different set of tools at their disposal than the NCAA would.
Yeah, and I agree, and I think that moving forward, it's pretty clear that the NCAA will get involved with this at some point. I know that the FBI apparently hadn't contacted the NCAA about all this until, obviously it became public, and there will certainly be an NCAA follow-up, and then those schools may be held accountable for the various coaches' actions. I think that falls clearly underneath the NCAA bylaws. So, those are possibilities. But again, but for what the FBI did here, you just don't see the NCAA uncovering this, which, I think there's tons of reasons for. Can't really necessarily blame them on that, but at the same time, it's so systematic apparently, and there's all these other examples. And like you said earlier, this actually came as a surprise to no one that this stuff was going on. And that's really kind of the deeper issue here is what's really wrong with the NCAA model as it exists right now. And, we were off air chatting about this, but I think that this particular incident may lead to some other changes vis-a-vis, existing lawsuits that are going on that attack the NCAA model, and particularly, Jeffrey Kessler's lawsuit, who is attacking the NCAA model, and it seeks to introduce a free market where, if a player actually does have value in the free market, they will get paid that much by the school or potentially by sponsors. And to me, if that were the case, these sorts of issues would be out in the open and legal, as opposed to behind closed doors and illegal.
Yeah, I mean, it's the same argument with respect to legal sports betting. You put everything above board, transparent. You wouldn't have the threat of the same kind of threat of corruption or undue influence. It's conducting all this in the secret or in the underground, which exposes, which creates a temptation, to violate the law, and really does, end up victimizing people. So this is going to be right in Jeffrey Kessler's wheelhouse. I wouldn't go so far as to say it will, be a game changer in the so-called Kessler lawsuit, but this is certainly something that bolsters his argument about the hypocrisy of the NCAA's, notion of amateurism.
Right.
Makes its holes all over it.
Yeah, I agree. And, I think the question just kind of boils down to, and it's kind of been the age-old question, is like, what do we want the NCAA to look like? Is it really this amateur organization where, um, you know, student athletes are participating because they love the sport and all of those good things as the NCAA has tried to perpetuate over the years, or really is this a money-making industry? Is this a business? And I think that college sports are, it's hard to argue that they're not a business at this point because they create a ton of revenue. There's a lot of interested shareholders, a lot of people making money off the business, but none of those, at least legally, are now the athletes. And so that kind of creates a lot of tension. And I think the greater impact of this case is going to be the pressure on these other avenues to change the NCAA model, like we just discussed.
Yeah, I mean, as Gordon Gekko once said, greed is good, but in this case, you have a system, a market system, which exploits the services of the talent, and the money is basically going around, and the university, the coaches, the alumni, nobody's making money except for the student athletes who have to resort to these measures. And it's not even their scheme. It's the scheme of the coaching staff, the alumni, the schools, the sponsors, to create this, funneling of money through illicit channels to provide the players something that they should have been getting or should be getting all along, which is some level of not only compensation, but fair compensation commensurate with the value that they bring. I mean, to cap it at the cost of tuition and or to set some arbitrary baseline figure of $5,000, which was the number in the name, image, and likeness case from O'Bannon. I think Kessler's lawsuit may have some legs, and this could be the incident that really causes people places the focus on that lawsuit as being the potential major force of change in college athletics. I mean, those of us on the inside who are sports law wonks know about this case, but I think the FBI, the FBI, investigation and the indictments and the growing nature of this case, I think will make the Kessler lawsuit, will give it the kind of attention that it really hasn't been getting to date. But I think that will be the case that could really shift the landscape in college athletics.
Yeah, or again, another parallel to sports betting, what's going on. It could put pressure on the NCAA to act on their own volition to change the model before it's forced upon them by the courts. But I think another really interesting aspect of all this is really how this impacts the sneaker industry, particularly Adidas, who obviously is implicated in all of this and was the source of a lot of the funds and was funneling money through third parties to pay players, families, other individuals involved in the scheme, it's interesting because now I think at least some people will look at Adidas and other schools that maybe have Adidas contracts and say, hey, are they shady with this school? It just really brings down their credibility. And honestly, I mean, if you're a university and you're negotiating a shoe deal and you're negotiating with Nike, Adidas, are you really going to want to go with Adidas at this point? What that would look like for your school?
Yeah, but you know what's going to happen here, which is what normally happens when one individual gets implicated. The company throws him under the bus and tries to implicate him or tarnish him as sort of a lone wolf or somebody who acted on his own and without any knowledge of any of his superiors or the company as a whole. Maybe the proof in this case, indicates otherwise. But I would expect Adidas to quickly throw this individual under the bus to salvage its goodwill and reputation, because otherwise the horribles that will befall Adidas will in fact happen that you just described. So I would expect to see some of that. I mean, the schools, and you just saw Patino do that in his public statement yesterday, that all those who are responsible should pay the price. And of course, the other of the statement, whether it's the university or the head coach, they never implicate themselves. It's always pointing to anonymous others as really being behind the scheme. So no one wants to own up and accept responsibility. Although I do see Louisville right away just kind of took the hit and acknowledged that it was the subject of this investigation and took action fairly quickly. So some schools will step up, but ultimately it's a matter of self-preservation, because if they fight these things, they'll end up potentially paying a bigger price down the road with greater criminal penalties, or just as troublingly NCAA sanctions. But I just found it very telling that Pitino was all high and mighty yesterday, and he pays for it with the loss of his job less than one day later. But hey, maybe he'll come back to the Knicks. I've always been so disappointed that he was a Knicks coach in the late '80s, did such a wonderful job, and then he had a falling out with the general manager Al Bianchi at the time, and the organization took years to recover. And I've been pining for Rick Pitino ever since to come back to the Knicks. I think he'll get a third, fourth, or fifth act. I don't necessarily believe his career as a legendary coach is at an end, but it sure looks that way today.
Yeah, I was just going to ask you what you thought. And that really is Pitino's move these days, is to just say, I didn't know about it. I didn't know it was happening. It may have been wrong. It may have been, someone else from his staff, but I sure didn't know about it. And, that's what he did in the escorts scandal, and that's what he came out with immediately after that. And, of course, Louisville apparently didn't really care about his opinion and immediately relieved him of his duties, which was, probably warranted at this point. But I wonder, Dan, if he's going to get ex-Baylor head football coach Art Briles treatment, where now he's just toxic. He's clearly has this stuff aside, has the resume to be a college coach, but
you can't create an equivalency between rape, sexual assault, and on the other hand, funneling money to an athlete that, let's face it, most of us believe college athletes should receive some level of compensation. I think maybe he's toxic in the short term, or maybe for another Division I major college program. But ultimately, he's in his 60s. He's in his mid 60s. He's got another 5 to 8 years left in his prime, and he's a winner. And he'll surface somewhere and win. He wasn't a cheater. He just did what everybody else in the business or what many in the business did. And I don't think this is going to stop with Pitino. I think this is going to go beyond, him and snare so many other well-known, programs and coaches. And after all is said and done, who's going to be coaching? You're going to need coaches. If this were just a Rick Pitino issue and something that was kind of engineered by him and only involved him, yeah, it might be the death of his career. But he's just too good, and everybody gets a second act. Well, maybe that Briles doesn't get a second act, but just about everybody else does. And I think he would, depending on what we later come to learn, he might warrant a second chance.
Right. Yeah, it's an interesting perspective, and I certainly wasn't trying to compare the underlying acts of those two cases, but I just thinking of how he's looked at, and I think with Pitino, you have to keep in mind that this is not the first time something like this has happened. He kind of showed over the last however many years that he, doesn't run the cleanest program, whether that was his exact fault or not, as we talked about. I think when you're talking to an AD of another major D1 school, they're not going to care. But again, we've also seen, like you said, let's wait and see what this comes out of this, because there may be a lot more people implicated. And second,
I wouldn't eliminate. Yeah, sorry. Go ahead. I'm sorry.
I was just going to say that, and on top of that, winning cures all. So I wouldn't rule out another chance, but I certainly don't see it in the near future.
Well, I mean, there are majors, and then there are mid-majors. And mid-majors want to become majors. And one way for a mid-major to become a major is to make a daring hire. And someone like Rick Pitino could transform a mid-major into a major. It could maybe a Florida Atlantic University. I mean, we're focusing on, maybe not the correct thing right now, but I've just been such an admirer of Rick Pitino's skills as a coach, his legendary career. I remember way back when he was UB Browns. He was on UB Browns coaching staff in the 82-83 season when UB came to the Knicks. He brought. I mean, he has been a turnaround artist. He's brought teams like Boston University, I think University of Hawaii, Providence, schools that have no business being on the basketball map. and he's brought them into the NCAA tournament, and in Providence's case, brought them to the Final Four. I believe it was the 86-87 season, which led to his being hired by the Knicks. So I believe that there'll be some school out there that would be willing to give him a second chance. Maybe not this year, maybe not next year, but at some point, I don't think we've heard the last of Rick Pitino.
Hey, Conduct Detrimental fans, we have some big news to report. We have our first actual sponsor for the podcast, and it's on a topic that's near and dear to our hearts, fantasy football. So if you love fantasy football, then you need to try our new favorite app, Draft. It's weekly fantasy football, but not like the other guys. On Draft, you draft real live snake drafts with other people, just like in your season-long league. Here's how it works. It's a draft that lasts for just 1 week, and there's no management. Just set it and forget it. Once you're done drafting, that's it. No trades, no waiver wire. Draft even takes care of the last-minute injuries for you. Drafts start every couple minutes, so you can join one right now. And the best part, you can play for cold, hard cash. Drafts start at just $1, so there's a draft for everyone. No salary caps, playing a real live snake draft, just like you play with your friends in a season-long league. Come join us on Draft today. Download the app at any time. Just search Draft in your app store and join a game in minutes. Or play right from your computer at playdraft.com, whichever way you want. For a limited time only, all new players get a free entry into Draft when you make your first deposit. But you have to use our promo code, which is SPORTSLAW. That's right, kind of detrimental fans. Play in a real money game for free by just using the promo code SPORTSLAW on your first deposit of the draft. Just search Draft in the App Store or go to playdraft.com and come play with our free promo code SPORTSLAW. And we're back at it. Yeah, let's just, I think that's probably a good point to just kind of transition into our next topic, which is the Ezekiel Elliot lawsuit. We've discussed that on the podcast numerous times before, but we just kind of want to, there's an oral argument in the Fifth Circuit coming up on Monday, and we thought it would be a good time to preview some of the things that's going on there. Dan, do you want to give us a little update on what the current status of that case is?
On Monday, let me back it up a little bit. In the Eastern District of Texas, Judge Amos Mazan had issued a preliminary injunction in favor of Ezekiel Elliot, finding that he would likely succeed on the merits of his lawsuit to overturn the arbitration ruling upholding the 6-game suspension, and that he would suffer irreparable harm if he were suspended. And the NFL in turn moved to stay, or basically issue a stay of the preliminary injunction as a precursor to suspending Elliott right away, even while the appeal of the preliminary injunction was pending. So the NFL wanted to impose the suspension right now while the case is being litigated, and that ended up playing out before the United States Court of Appeals for the Fifth Circuit. And I've written and I've maintained that the NFL has no chance, or shouldn't have much of a chance, in succeeding because Elliott can demonstrate irreparable harm, whereas the NFL cannot. And irreparable harm is one of the requirements that the league will need to show in connection with its motion for a stay pending appeal. It's the same requirements that govern the preliminary injunction. So how can the league possibly overcome that? Well, the league had a trump card, which is the jurisdiction argument, and the league argued that the Eastern District of Texas Court lacked any subject matter jurisdiction over the controversy because at the time the lawsuit in Texas was filed, arbitrator Harold Henderson hadn't yet issued his arbitration award, and the law is well settled. The NFL's position is that the law is well settled, that federal courts lack the power to intervene in ongoing arbitration proceedings, and the earliest juncture at which the court can entertain a review of an arbitration is after the award has issued. So that is at the heart of the NFL's jurisdictional argument, and the Fifth Circuit issued an order late last week calling for additional briefing on the jurisdictional issue and setting it for oral argument on Monday, which is 4 days from now, at which time the court will decide whether the case should stay in Texas, or whether the injunction should be thrown out and the lawsuit thrown out, in which case the controversy would then shift to the Southern District of New York, with who's filed a parallel proceeding to confirm the same arbitration award. Sorry for the long wind-up, but it's kind of hard to encapsulate all of that in anything less than like 30 minutes.
I think so. Just to highlight some of the key points there, I mean, based on how the Fifth Circuit's proceeding, I think one can glean that they sort of agree on the irreparable harm issue potentially, and they really want to focus on the jurisdictional issue instead. And like you said, those are kind of separate issues. And really, what the PAs are arguing is that we understand that the general rule is that you need to exhaust all of your remedies at the lower level at the NFL arbitration process before you can move forward, generally. But there's exceptions to that, and one of which is that if it's essentially futile to do so because the violation has already occurred. And so some of their arguments were that during the NFL's process there was issues with the investigation, and that gave them immediate ripeness or standing or no need to exhaust their remedies at that point and establish jurisdiction at that point moving forward. So to me, the Fifth Circuit asking for oral argument, asking for additional briefing, really focused this appeal on that one issue, and it really is going to be the key issue moving forward in this case. Do you agree?
Right, because I totally agree, because irreparable harm alone would have been enough to deny the motion. So I think subject matter jurisdiction goes to everything. It doesn't matter if the NFL can't satisfy the other requirements for a stay, but they can show that the court lacks the power to hear the case. Well, doesn't that trump everything? It no longer becomes an analysis of a four-part test. The case becomes dead on arrival. If the Texas court lacks subject matter jurisdiction to hear the case, the Fifth Circuit can dive in right away and order the case to be dismissed without having to wait for the full appeal on the merits of the preliminary injunction or even the full appeal following the vacator of the arbitration award. Subject matter jurisdiction is a defect that can be raised by the parties or by the court at any time, and at any time encompasses this particular hearing. And if the Fifth Circuit believes that there's a jurisdictional obstacle or any defect, it will remand the case to Judge Mazant with instructions to dismiss it. And the way that, based upon the court setting an oral argument on a motion of all things, literally, in my entire 20 years of appellate practice, I have never known, and I've handled more than 100 appeals, never had a motion set for oral argument in an appeals court. The fact that it's that unprecedented and that there was such a clear disparity on the irreparable harm issue suggests that the Fifth Circuit has some real concerns about the justiciability of the NFLPA's lawsuit and filing it when it did pre-award.
Yeah, and to kind of crystallize why this particular issue is so important, right? So let's just take a look at the two paths. So the first path is, let's say that the PA is able to convince them that they had jurisdiction, and assuming that they also went on the irreparable harm issue and all the other factors that go into the preliminary injunction, which seems like they have a good chance at, the case will be, or the appeal will be lost, essentially. The lower case will proceed, and Judge Mazant has already indicated that he thinks that the PA has a likelihood of success to win that case. So off and running in the right direction for the PA. They would at least look good there. It would have to be, the final disposition would have to be appealed, presumably, and move forward. However, as you just described the process, if the NFL wins this, the case would be remanded, dismissed, and now we move over to New York and basically start over. The NFL has a placeholder lawsuit filed in the Southern District of New York, where we saw Tom Brady's case and other NFL litigation in the past. It's where they're headquartered. And we really just don't have an idea of how things would proceed in that course. Of a new judge, we're going to have to relitigate some of these underlying issues. So it'll really change the dynamics of the entire lawsuit moving forward.
Yeah. Personally, I think the NFL's ploy to get this, I mean, it's a good jurisdictional argument, don't get me wrong, but there's jurisdiction somewhere, right? The NFLPA certainly has at this time, now, today, has an avenue of judicial review. And this is not a question of, well, the jump the gun and they don't get any judicial review. This is just engineered to shift the case over to New York, where the union would have another opportunity to go through the same arguments, the same motions, the same hearings that have already occurred in Texas. I don't see the prejudice to the NFL other than that they didn't get their way. I mean, after all, the plaintiff does get to choose the forum, and typically in a review of an arbitration award, I wouldn't say statistically, but more often than not, it's the aggrieved party that wants to challenge. If there, quite often there's a motion to confirm the arbitration award, but in this case, I think the NFLPA stands in the shoes as a traditional plaintiff and should have its choice of forum, and the choice of forum would either be, where the locus of events occurred, or where the parties are located, or where the arbitration occurred. And I believe under federal arbitration, FAA case law, generally it's where the arbitration occurred, but that is not a hard and fast law. And I think this is not a jurisdictional battle as much as it is a venue battle. And I think if the court takes a step back, it would understand that that Judge Mazant did not interfere with ongoing arbitration proceedings. His ruling on the preliminary injunction occurred well after an award was issued. It was only the filing of the lawsuit that predated the award. And when you think about all the work that has already taken place in the Eastern District of Texas, thousands of pages of briefs and exhibits, an oral argument lasting several hours, several decisions on a preliminary injunction and a stay issue, and to start that process all over again in me would seem to be an utter waste of judicial resources, and it would frustrate judicial economy. So I believe that if the court wanted to take a practical approach to this, what the court could be thinking would be, well, the union's going to have its day in court no matter what, the case is right now. The union has standing right now, and the union has exhausted all of its remedies right now. So is this about having jurisdiction at all, or is it really a question of which venue is the right one? And I think since there's going to be a litigation and there's going to be some federal court with venue, I think it makes the most sense to leave it exactly where it is. So I think there are competing considerations. On the law, I think maybe the NFL does have the better of the arguments. Mm-hmm. But if you look beyond the law and just look at judicial economy and look at what would be, kind of the most efficient use of resources without frustrating jurisdictional principles, I say leave it where it is.
Yeah, I think you're correct in saying, I don't necessarily agree with your ultimate conclusion, but both sides have compelling arguments. And I think the big one for the NFL is, what kind of precedent does this set that someone can just jump the gun like this and get to litigate the lawsuit where they want to? I see where the NFL is coming on that point for sure. And
but it's their own doing, because several years ago in Deflategate, the NFL manipulated or controlled the timing of the release of Roger Goodell's arbitration award in the Brady case, and then ran to federal court in the Southern District of New York simultaneously before the NFL Players Association had any idea what hit them. So the reason why the PA had to file pre-award was to safeguard or guard against the NFL pulling the same gambit that they did in Deflategate, and repeating it in Elliott. Because even though Harold Henderson is sort of not the NFL, he's really the designate of Roger Goodell and has such a close affiliation with the league that I don't think he could have necessarily been blindly trusted by the Players Association not to tip off the NFL. If the union had waited, they would have lost the courthouse race.
But at the same time, this kind of goes deeper down the wormhole of the NFL CBA, and on one hand, that's a valid argument. On the other hand, the players negotiated this agreement, and in the agreement it says that Roger Goodell can be the arbitrator on these hearings. Clearly, that's clear in the CBA. And what comes of that is he's the head of the NFL. He knows when he's going to release his ruling, and it gives them a tactical advantage to be able to file in the venue of their choice on time. So
But I think that provides an unfair tactic. But I think that tactical advantage is unfair. While the union did acquiesce to this particular system of arbitration and this particular mechanism to have the now handle both the initial discipline as well as the appeal, I get that was slightly bargained for. But what was not bargained for was the manipulation of the timing of when decisions get released and to place. If the NFL believed it was so important to litigate in the Southern District of New York, it could have bargained for that in the collective bargaining agreement that the site of any federal lawsuit challenging an arbitration award shall be in the location of where the arbitration is held, or the Southern District of New York. So the NFL is equally at fault for not negotiating that, and what it failed to accomplish in negotiation, it's seeking to accomplish by taking unfair advantage of certain knowledge that the arbitrator possesses, but that the adversary does not. I don't believe that the NFLPA bargained for the NFL's preferred choice of venue. That's not anywhere in the.
Sure. Yeah, it's not. But yeah, I mean, we could talk about this all day.
It's so fascinating. I love talking about it. I mean, we're disagreeing, but it's a fascinating point.
The language. Yeah, I mean, it's a consequence of the language, and it may be one that at the time was hard to foresee, but it is something that goes along with allowing the head of an organization to act as the final arbiter of an appeal. You have to kind of understand the company ties that go along with that, and then the litigation that goes along with that too. And frankly, I don't think the time the last CBA was drafted, there was probably as much concern with all this venue fighting. I don't recall that being from earlier, but anyway, it should be an exciting, another exciting week of Ezekiel Elliott, and I'm sure this NCAA thing that we chatted about is going to blow up even more, and we'll have Sunday to look at what the players do during the national anthem. So another fun week of sports law ahead, Dan. Anything else that you wanted to mention before we go?
No, other than recommending that we start doing this daily. We can't keep up. I know we revisit a lot of the same cases over and over again sometimes because the Elliott case really is beginning to capture. It's a national story. Anytime you're talking about the NFL, it raises much greater awareness than if we're talking about the NBA, hockey, baseball, or sports gambling. So I know our audience would really like to dive into Ezekiel Elliot just as we would, because it's in the headlines, and it's probably the most interesting game of chess moves that I'm observing right now in the whole field of sports law. You're talking about two of the brightest strategists in the country, Jeffrey Kessler and Paul Clement. Two sides, not Kessler and Clement, but two sides absolutely can't stand each other, basically jockeying for the upper hand in federal court litigation through parallel lawsuits and emergency motions. I mean, this is about as exciting as it gets in the field of sports law commentary. So we got to keep going back to the well again and again until the case begins to quiet, and that won't happen for at least 17 weeks.
Yeah, and one related point, and I know we have many lawyer listeners that may be interested in attending, but there's an ABA sports conference in Las Vegas, which Dan and I both spoke at last year. I'll be back there again. It's next Thursday, Friday, and Saturday. And on Saturday, we have a one-on-one interview with Jeffrey Kessler, Ezekiel Elliott's attorney.
Oh, wow.
And he's being interviewed by Ebony Williams, who's a Fox News host and reporter who's also a lawyer. And we're actually working on live streaming that over Twitter. So not only if you're at the conference, but anywhere you are on Saturday, mid to late morning. I'll probably have it on my Twitter account as well as the ABA Entertainment and Sports account. So I'll make sure to disperse that information, but it should be a really interesting interview, and we should get some insight into these cases and more, because he's really involved in quite a few, and it should be a fun one. So, all right, Dan. Well, I think that's it for today. Thanks everyone for tuning in. Let us know any feedback that you have. Good ratings on iTunes only. And thanks for listening. We'll see you next time.
Thanks, everybody.